Good afternoon, everybody. We're going to get started to accommodate the commissioner's schedule. Please continue with your lunch, and if you need to, get up to grab a cup of coffee or dessert. So it is our pleasure to welcome Commissioner Terrell McSweeny from the FTC. And as you know, for our lunch series, we bring in current and former enforcers, and we basically generally take turns between the DOJ and the FTC. And Patty Brink is with us as a former speaker from the DOJ, and I think you're probably the only speaker to then return to just enjoy the colloquium as well, but that's true for any and all, and we hope that Commissioner McSweeny will be back in future years as well when she has more time. So as you know, Terrell McSweeny has served as a commissioner at the FTC since April of 2014, and prior to joining the commission, she served as chief counsel for competition policy and intergovernmental relations at the DOJ Antitrust Division. So she's, again, one of the handful of enforcers to serve in significant positions in both agencies, which also includes Bill Baer. She joined the Antitrust Division after serving as Deputy Assistant to the President and Domestic Policy Advisor to the Vice President from 2009 to 2012. Her governmental service also includes work as Senator Joseph Biden's Deputy Chief of Staff in the U.S. Senate and as counsel to the Senate Judiciary Committee. She also worked as an attorney at O'Melveny & Myers. She's a graduate of Harvard University, Georgetown University Law School. We're thrilled to have her here today. She'll be talking on the theme of competition and innovation in high-tech industries. There will be a Q&A after her comments. And I'll be serving as the mic person, bringing the microphone around so everyone can hear. And then I would just ask Commissioner McSweeny if you could repeat the question, then we can pick it up for the taping system. So without further ado, please welcome Commissioner Terrell McSweeny.
You know what? I forgot to bring my water glass. Thank you so much. Thank you for having me here today. Please feel free to enjoy your meal while I'm talking. It doesn't bother me at all. And if you can't hear me in the back, just raise your hand and wave a little bit and I'll speak up. I really appreciate that really nice introduction and being here at this event. And this morning's discussion, which I caught at least the second panel, was incredibly interesting and provocative. It's great to see old friends, Rachel Brandenberger and Patty Brink here, my former colleagues at DOJ. I consider myself to be incredibly lucky to have been able to serve at both the Department of Justice Antitrust Division and the Federal Trade Commission, different but really wonderful antitrust enforcement agencies. You know, after this morning's discussion, I think I'm going to rename my remarks, which were titled something like Competition Law Keeping Pace in the Digital Age, which is sort of a boring title, to Enforcers' Perspectives on the Sponge, which is kind of exciting. Maybe the sponge and the salad and the language. I really loved that discussion. It underscores one of the things that I really enjoy about the practice of competition law, which is that it touches so much of the economy, the products we buy and the services we use and the industries in which we work. So this event really highlights a lot of that fascinating discussion and many of the topics that are on the forefront of the issues that we think about on a daily basis. And is quite timely. You all were busy this morning, but the President of the United States actually issued an executive order this morning on competition and spurring competition. He's directing executive departments and agencies to take steps to promote competition within their areas of responsibility. And I think that the main takeaway from that is that it kind of follows on the sponge theme. Competition enforcers don't really have to have a monopoly on competition policy issues, and I think that's actually a very good thing. We have a vital job to do in enforcing antitrust laws, but competition as a value and as an important factor actually is far more expansive in our economy, and I think it's terrific that the President is directing agencies to really think about competition in the course of their mission or in their regulatory mission in the industries in which they work. This is something that Patty Brink actually taught me when I was at the Department of Justice, where I worked quite extensively on the portfolio that we refer to as competition advocacy. But it's when the competition enforcers spend time thinking about policy questions that have a competition value or bring to bear the competition toolkit on an interesting issue and reflect it to another agency and help them think about it as well from that perspective. You know, the order was also accompanied by an issue brief from the Council of Economic Advisors, which noted that there are several indicators suggesting that competition may be decreasing in many sectors in this country. And I think academics have really debated some of the causes for this shift, and the paper points out that more research is really necessary before we draw any conclusions about these trends. But it underscores for me one thing that I think is very clear, which is that enforcers are going to need to continue to play a very important role in preserving competition and protecting consumers. And we're going to need to use all the tools in our toolbox when we're thinking about our mission. So I'm going to talk a little bit more about that in a moment. But before I go any further, I need to give the usual disclaimer, which is that I am here today speaking on behalf of myself and not the Federal Trade Commission and not my two remaining colleagues. I give that disclaimer because that way I can have my own opinions and hold forth, and hopefully you won't extrapolate anything that I say to them. With that out of the way, I'll turn to my topic of the day, which is the role of competition enforcers in the digital age. Some say that the new economy competition is different from competition in old economy markets. You might have heard this before, that antitrust law and competition enforcers can't keep pace with the rapid change in high-tech markets. They suggest that antitrust enforcers should not intervene in dynamic markets, given the risk that even well-intentioned enforcement may do more harm than good. And others view competition law as a vehicle to address emerging issues related to privacy and data security. So we see these two really different perspectives surrounding the use of the competition toolbox in this space. And I suggest that either approach would really create a lot of new rules for the road for competition law. So here's what I believe, that antitrust enforcers play a vital role in protecting competition and innovation in high-tech and digital markets, and must continue to do that. And I think the President's announcement today really underscores that. And that we have the tools and the ability to make a difference. Competition in digital and high-tech markets may operate differently than in certain traditional markets. For example, pricing may play less of a role in many high-tech markets where products and services are frequently offered to consumers for free. And economies of scale in competition, commonly referred to as network effects, may play a greater role in certain digital markets. A social network, for example, that has more users than any other social networking site may increase in value to its users. The effects of scale may make digital markets more susceptible to consolidation of market power. And at the same time, entry may be easier in many digital markets compared to traditional markets that require substantial upfront investment in physical plants and equipment. These market factors are important, but our antitrust tools are flexible, so long as we are careful to apply them with sensitivity to the competitive dynamics of digital and high-tech markets. We do not need a different set of rules to address these factors. And we absolutely should not turn a blind eye towards anti-competitive behavior in high-tech markets simply because we cannot predict the future with certainty. Today, I'm going to talk about a few of the issues related to competition enforcement in digital and high-tech markets. First, I'm going to talk a little bit about innovation in market analysis and describe how innovation considerations often play an important role, even in cases where agencies do not specifically define an innovation or R&D market. Second, I'm going to talk a little bit about some of the emerging issues related to big data, when we should treat data as a relevant market, and the appropriate role of privacy and data protection considerations in competition law. And lastly, I'm going to touch briefly on some of the potential antitrust frontiers in the digital world, picking up a bit on the discussion that was had here this morning. So first, considering harm to innovation and merger review. I think we all agree that innovation is important, so is consumer welfare. It's kind of in that big circle that we started with in your presentation, Professor, where we agreed on some core values. And the circumstances that best promote innovation are difficult sometimes to pin down. Economists have really drawn no firm conclusions about the existence of a general relationship between market structure and innovation. Yet in individual merger cases, innovation effects can be predicted with some degree of confidence. In these cases, antitrust enforcers should and do incorporate innovation effects into our analysis. And for this reason, the revised 2010 horizontal merger guidelines include a section that specifically addresses innovation effects. In traditional commodity markets, like cement, for example, we generally can analyze the competitive effects of a merger by looking at price and quantity. If a particular merger is likely to raise prices or reduce quantity, we can reasonably be confident that the merger is anti-competitive. Everybody in this room probably is well aware of those ideas and would agree with that assertion. But for many digital markets, a traditional price-based approach to competition analysis may be ineffective. This is particularly true in what are known as two-sided markets, where one side may subsidize the prices users pay on the other side. Indeed, in the digital context, there are myriad examples of products and services offered to consumers for free, such as internet search engines, social networks, booking engines, and software. Competition can be vigorous even where products or services are offered for free, and often that competition takes the form of innovation to provide customers with quality improvements or new products. The issue then is whether to look at just the price effects on the paying side of these platforms in our analysis, or whether to consider harms such as quality and innovation on the free side. And the guidelines section on innovation makes clear that we look at both sides in a merger enforcement context. This is precisely what the FTC did in its review of Zillow and Trulia, which the Commission voted unanimously to close last year. On the paying side of the platform, staff investigated whether a merged Zillow-Trulia would be able to profitably raise advertising prices to real estate agents. But staff also examined whether the merger would reduce the combined entity's incentives to innovate by developing new features attractive to consumers, ultimately concluding that it would not. The FTC routinely challenges mergers that would harm competition in the research and development of new drugs and treatments, and in some situations, we may look specifically at an innovation market or an R&D market. But innovation is often a key factor in conventional antitrust analysis. When a firm is planning to enter or expand its presence in a particular market, there are often some meaningful innovation at the heart of the firm's business plan. 3 recent examples from the FTC enforcement proceedings illustrate this point. First, the Commission's challenge in late 2014 of Verisk Analytics' proposed acquisition of EagleView Technology, a case that focused on the market for rooftop aerial measurement products, commonly known as roof reports. In this situation, EagleView was the leading U.S. provider of roof reports. Verisk was the leading provider of downstream software platforms, but had recently made a foray into the market for roof reports themselves. There was strong qualitative evidence that Verisk was uniquely well-positioned to compete against EagleView in providing roof reports. And one of the things that the FTC examined very carefully was the likely future competition between the merging parties to offer consumers more innovative products. In particular, Verisk had invested in capturing high-resolution aerial images that were slightly better quality than those used by EagleView, which promised even more accurate measurement tools in the future. So while the FTC did not define an innovation market per se, innovation nonetheless played a crucial role in the staff's analysis and in the decision to challenge the merger. And subsequently, the parties abandoned the transaction, and Verisk accelerated its collection of aerial images entering in the market. The second example is the FTC's challenge last year of the merger between Steris and Synergy, the second and third largest sterilization companies in the world. Synergy did not operate in the United States, but company documents show that it was working to introduce an innovative X-ray sterilization technology into the United States to compete directly with Steris. While other forms of sterilization exist in the United States, none of the existing market participants offered X-ray sterilization on the commercially significant scale. The Commission alleged that the merger would harm future competition by terminating Synergy's entry plans and would deprive consumers of a promising new sterilization technology. Unfortunately, as many of you are doubtless familiar, last September the district court judge denied the FTC's request for injunctive relief. The judge disagreed with the FTC that Synergy would have entered the U.S. X-ray sterilization services market within a reasonable amount of time to compete against STERIS. So the commission subsequently dismissed the administrative action in that case. And while I disagreed with the judge's conclusion, this matter nevertheless provides a concrete example of the commission's willingness to take innovation and quality competition seriously by considering the potential disruptive effects of new technologies. The third example is the commission's 2013 consent decree in Nielsen Arbitron. In that case, which was before my time at the commission, the FTC required a divestiture of competitive assets because the merging parties were the best positioned firms to develop the platform audience measurement product that was sought increasingly by media companies and advertisers, even though that product had not yet been developed or marketed. I would be remiss if I didn't note from my colleagues at the Department of Justice that the Department of Justice has also looked carefully at these issues in merger analysis. Of course, 2 years ago, the DOJ prevailed in a challenge of Bizarre Voice's consummated acquisition of Power Reviews, a case involving online product review and ratings platforms. And in that case, I think importantly in the judge's opinion, the court acknowledged the fact that the industry was in a very early stage of development, rapidly evolving, fragmented, and subject to potential disruption by technological innovation, and on a whole, though, concluded that Bizarre Voice hadn't actually presented sufficient evidence to preclude the anti-competitive effects from the transaction, which I think was a really important note. It suggests that even in highly dynamic markets, changes in market structure may be episodic and infrequent, and also that the potential for disruption, which is something that we all are very mindful of, does not necessarily preclude an antitrust action, especially if there's no evidence of it. So I'm not suggesting that the continued success of the innovation theories in courts are going to be weaker. I think it just by the FTC's case in STERIS, but I do think that it shows that courts are handling these issues and enforcers are bringing these cases, and we will continue to have a very vigorous debate around those questions in merger review. So I'm going to turn now to my next topic, which is also innovation related, which is big data, privacy, and antitrust. This is kind of a hot topic for us at the FTC because it combines things we love, which is consumer privacy and competition enforcement. And I think it's a really tricky topic, as doubtless has been discussed earlier this morning. You know, big data means a lot of things to a lot of people, but for purposes of my discussion right now, I'll refer to sort of big data or data as more or less the lifeblood of many high-tech markets. And I think the first question for antitrust enforcers is, can big data constitute a relevant market? And can big data be a barrier to entry? And I think the short answer to both of these questions is yes. The antitrust agencies can take a case-by-case approach to looking at markets and potential barriers to entry. I'm not aware of evidence today that warrants treating big data as a special case, however, either by inferring that it conveys market power or operates as a barrier to entry on the one hand, or by categorically exempting it from antitrust scrutiny on the other. In the big data world, there's a lot of data that anyone can obtain for fairly nominal cost, but there's also a lot of valuable data that is proprietary and could operate as a barrier to entry. It may be, for example, that an incumbent has significant advantage over new entrants when a firm has a database that would be difficult or very costly or time-consuming for a new firm to match or replicate. The FTC has treated data as a relevant market and found it to be a barrier to entry in recent cases based on specific facts and circumstances related to the competition in those markets. For example, in Dun & Bradstreet quality education data in 2010, the FTC determined that data itself was the relevant product market, And the FTC found that the parties were the only significant U.S. suppliers of K-12 educational marketing data. Other sources of marketing data were not close substitutes because their coverage was more limited and their functionality was reduced and their data sets were less frequently updated. In Nielsen Arbitron in 2013, the FTC similarly determined that proprietary data of Nielsen and Arbitron was the key input to offering downstream cross-platform audience measurement services. The parties had the most accurate and preferred sources of individual-level demographic data for television and radio audience measurement purposes. And in other words, it would be very difficult for other firms to replicate the data generated by Nielsen and Arbitron. So the FTC found that access to television audience data with individual-level demographic information to be a significant barrier to entry at that time. And the consent required a divestiture of assets related to Arbitron's cross-platform audience measurement business, including data from Arbitron's representative panel. The FTC also treated data as an input in the market for electronic public record services for law enforcement customers in the Reed ChoicePoint transaction in 2008, and I won't go into a lot of detail on that for the sake of time, but I'll note that again there the FTC found that the parties' combination of data and analytics were unique among electronic public record services, and that other firms which also possessed what could be described as public records versions of big data, but the quality of the data in the terms of the breadth and depth of it and the analytics offered in connection with the data were insufficient to enable the other firms to compete effectively for law enforcement customers. On the flip side, the FTC has decided to close investigations involving big data, such as when it closed the Google DoubleClick investigation in 2007. Staff examined whether the combination would enhance Google's power in the ad intermediation market and concluded that it would not. The FTC found that neither the data available to Google nor the data available to DoubleClick constituted an essential input to the successful online advertising product. So these examples highlight the fact that there is no one-size-fits-all approach to data holdings, and that appropriate antitrust analysis to this issue is a fact-specific enterprise. That's hard to say. So this leads me to the next hot topic in big data, which is, should competition focus on privacy and data protection, and if so, how? As businesses have come to increasingly rely on big data, privacy and data protection concerns have become frequent topics in this discourse. Some have suggested that competition law should focus more on privacy and data protection issues in analyzing platforms and other high-tech industries. Others, particularly in Europe, have suggested that competition law should be used as a tool to improve privacy and data protections offered to consumers. In general, I see antitrust review and broader policy concerns regarding privacy and data protections as two separate issues. As I mentioned earlier, competition law in this country is a very flexible tool. The U.S. antitrust agencies routinely analyze non-price considerations where there is evidence that those non-price considerations are important to competition. The FTC has yet to challenge a merger specifically based on the likelihood that it would lead to diminution in privacy protections, but we have recognized that the consumer privacy can be a non-price dimension of competition. I mentioned the Google DoubleClick case a little bit earlier, and in that matter, the FTC considered whether merger of Google and DoubleClick's respective consumer information data sets could be exploited in a way that threatened consumers' privacy as part of its competition analysis. And while the majority of the Commission did not find any evidence to support that theory in this case, I will continue to encourage staff to explore these topics of theories going forward. As companies start to compete and differentiate products based on privacy and security offerings, these theories may become more important in the future. Absent a clear nexus to competition, however, privacy and data protection concerns are best handled as consumer protection issues. For example, in the Facebook WhatsApp transaction in 2014, staff from the FTC's Bureau of Consumer Protection focused on how the merger would affect the promises that WhatsApp had made to consumers about the limited nature of the data it collects, maintains, and shares with third parties, promises that exceeded those that Facebook at the time at the time of the merger. Our staff in the Bureau of Consumer Protection concluded that it was appropriate to alert the companies about these privacy concerns and to assure the public that the protections of applicable law, including Section 5 of the FTC Act and the FTC's 2011 order against Facebook, would apply to WhatsApp's data. In other words, the companies couldn't change the privacy policies and handling of the consumer data without clear notice and choice and consent from the consumers. This was a consumer protection issue, and it was handled appropriately as such. On the competition side, our Bureau of Competition staff allowed the transaction to proceed with no conditions. Similarly, concerns were raised last year regarding Radio Shack's proposed sale of its database of customers as part of its ongoing bankruptcy proceedings. Several states objected to the proposed sale on the grounds that Radio Shack had promised customers that it would not resell its consumer data to third parties. Our Bureau of Bureau of Consumer Protection Director, Jessica Rich, wrote a letter acknowledging the special circumstances involved in the bankruptcy proceeding and providing guidance on how Radio Shack might transfer customer information in a manner consistent with the promises that it had made about privacy to consumers. The European Data Protection Supervisor has recently suggested that consumers do not appreciate the actual cost associated with free products, and that it may therefore be necessary to develop a concept of consumer harm, particularly through violation of rights to data protection for competition enforcement in digital sectors of the economy. And I think if you break this language down, the concern seems to be that consumers are not as focused on privacy and data protection practices as they should be. I'm open to the possibility that consumers may systematically underestimate the effects of privacy or data protection practices, or that they may simply make the rational decision that it isn't worth the time to fully evaluate those costs. But I think one interesting point in the European Data Protection Supervisor's report was that it would take an internet user, for example, an average of 244 hours per year to read the privacy policies associated with each website they viewed, which goes to show you the complexities here, which is why the FTC, as a consumer protection enforcer, has spent a lot of time advocating for greater transparency to consumers, for greater choice to consumers, and for legislation that would provide additional privacy protections to consumers. Moreover, the agency devotes a lot of its research to also understanding better tools for disclosure to consumers on these complicated issues. At the same time, I believe it's dangerous to engage in competition analysis based on what we think consumers should want or value, independent of market realities. To do so is to cross the line from antitrust enforcement into market regulation. And I think, however well-intentioned, it's really not the appropriate role of antitrust law. If market participants are competing on the basis of privacy or data policies to attract consumers, that would certainly be an element of competition analysis. But if they aren't, and if there isn't evidence that those dimensions are particularly relevant to competition, then using competition law to address privacy or data issues is like trying to force a square peg into a round hole. To the extent that there is a solution to this problem, it should be legislative, regulatory, or consumer protection law enforcement, not using the antitrust laws to solve policy issues that they are ill-suited to address. So I'll conclude, because I want to make sure that we have enough time for questions, by noting some of the new frontiers in antitrust law that are made possible by our wonderfully digitized new world. And I think this is also part of the discussion this morning, which is, given the rise of high-velocity computerized markets, algorithms, right, and machine learning, what are the roles for antitrust enforcers? Last year, DOJ brought a case for price fixing against two e-commerce sellers who agreed to align their algorithms to increase online prices for their goods, in this case posters. And in this situation, the humans actually agreed to use algorithms based on prices in conformity with their agreement. So it was pretty traditionally a price fixing case. I think there's a host of really intriguing issues, though. Traditionally, there are three challenges to maintaining a collusive scheme: detecting cheating among the participants, responding to new market developments, and avoiding detection by antitrust officials. algorithms could be used in an attempt to overcome these challenges, such as by automating conspirators' responses to changing market developments and mitigating the need for ongoing coordination between the participants. There's also the possibility that as algorithms become more sophisticated and the velocity of this technology increases, that they may be more likely to engage in consciously parallel behavior. And in fact, Professors Stuckey and Ezraki both participated in these morning's discussions, have co-authored a paper on artificial intelligence and the enforcement challenges that may be raised by collusion involving pricing algorithms. They suggest that it may be difficult to challenge algorithms engaged in conscious parallelism under current laws, absent awareness or intent by the humans using the technology. And they urge policymakers to recognize the dwindling relevance of traditional antitrust concepts of agreement and intent in the digital age. So beware the mind-control computers, in other words. I think this is the cutting edge of antitrust enforcement, and one that I certainly have urged our staff to be very mindful of and to continue study carefully. And also thinking about it in the merger context as well. You know, an increase in sophistication of pricing algorithms could also lead to narrower product market definitions in the future. Under the 2010 Horizontal Merger Guidelines, we specifically evaluate the possibility of price discrimination against targeted consumers or customers. Big data and algorithms enable sellers to more effectively target and price discriminate against specific customers. Thus, even though a company may not have been able to effectively target certain customers for higher prices in the past, that in itself is no guarantee that it may not be able to do so in the future. So data is becoming more robust and algorithms are becoming more powerful. And the Commission has itself already defined markets on the basis of price discrimination in its successful challenge to the Cisco-US Food merger last year. So I would not be surprised to see the concept of price discrimination markets take on an increasing importance as US antitrust agencies evaluate these issues going forward. So I've definitely talked about a range of different innovation, big data, privacy, technology frontiers, and antitrust law. I want to make sure that I have time for questions and look forward to hearing any comments that you have. And feel free to ask questions that aren't on these topics at all. I will open the floor.
Can everybody hear me? Thank you very much, Commissioner McSweeny. Let's open this up. I'll just ask people to speak into the microphone and identify yourself. And hopefully this will all work. And we can pick up both the Q&A.
Thanks, Terrell. That was really terrific. Rick Burnett, American Antitrust Institute. That's an announcement. Just wondering whether we could share the extent to which entities were involved in
So I certainly can't comment on the extent to which DOJ was, because I wouldn't know, and I'd stress that the Federal Trade Commission is an independent agency. That said, I was aware of it. I don't know if my colleagues were or not.
So, picking up on the events you said in the previous question, it seems to me that the DOJ and the FTC have done a really great job in talking competition law to the Patent and Trademark Office in the past decade and a half. And my question is, I'm wondering how that conversation is going with the Copyright Office, which is involved in a lot of really significant competition law issues and currently retains precisely no economists on this stuff whatsoever. And in my view, it's a poor job on these issues.
So I'll reserve judgment on the Copyright Office. They have a tough job. I think they have been considering a wide range of issues in thinking about exemptions and everything else. Certainly, I, as a former competition advocacy advocate within the Department of Justice, deeply agree with the idea that the competition enforcers have a wonderful set of tools and understanding of competition dynamics that can be very helpful to other agencies that need to think about these issues in order to get the balance right in order to optimize innovation. So I think I'll leave it at that.
Harry First from New York University, thank you for your remarks. Very interesting. Just a comment on the executive order. I hope you're ready for the onslaught of complaints from agencies around the federal government, because it says they're supposed to call you.
Well, not me personally. I mean, the Department of Justice too. Yeah.
But a question. Two cases seem to come up in these discussions: the Google Google DoubleClick merger and the Facebook WhatsApp merger. So I wonder if the Commission would consider doing a merger retrospective on these two. It seems to me we really don't. We're in an area where we don't quite know sort of what's going to happen. I think that the DoubleClick merger came up early, so these might be really right for.
I think that's a really. Yeah, that's an interesting suggestion. So we are actually doing a remedy study right now, but it's to 2012 because you need some period of time in order to see what has happened. And I think the Facebook WhatsApp transaction would be outside of that. Plus, it doesn't have a remedy in it. That's a antitrust one. I think it's a really interesting suggestion. One of the real challenges, of course, with looking at combinations that were allowed to proceed, especially if they were allowed to proceed without conditions, is that it's very hard to know what you're comparing, right? So it's kind of a apples to question marks comparison.
Speaking of high-tech industries, obviously we work with defense. I know that the FTC and the Department of Justice just came out with a statement about that. Is there some specific reason why that industry is targeted as opposed to the
I wouldn't say that industry was targeted as much as it's a really good thing when the Department of Justice and the antitrust enforcers say things like competition is a really valuable thing and we're going to care about it in our procurement process, and are able to articulate that in a very transparent way. You know, those are two agencies, or those are agencies that do have to frequently consider the effects of transactions on their various missions. And I thought it was a really helpful statement a very transparent statement about how they will approach that analysis. So that was my take on that. I mean, certainly, you know, the FTC and the Department of Justice haven't been shy in joining together and making comments about a wide range of different competition policy issues. And I think it's great when all of the enforcers can speak together with one voice on some of these things.
Let me thank the Commissioner, and I'd ask you all to join me in thanking Commissioner McSweeny.